The legal history of the Catholic Church is the history of the oldest continuously functioning legal system in the West, much later than Roman law, but predating the evolution of modern European civil law traditions. The history of Latin canon law can be divided into four periods: the jus antiquum, the jus novum, the jus novissimum, and the Code of Canon law. In relation to the Code, history can be divided into the jus vetus and the jus novum. Eastern canon law developed separately. Latin canon law, jus antiquum. The most ancient collections of canonical legislation are certain very early apostolic documents known as the Church Orders. For instance, the traditions.The apostolon, or teaching of the 12 apostles, which dates from the end of the 1st of the beginning of the 2nd century. The Apostolic Church Ordinance, the Didascalia, or teaching of the apostles, the Apostolic Canons and Apostolic Constitutions. These collections have never had any official value, no more than any other collection of this first period. However, the Apostolic Canons and, through it, the Apostolic Constitutions, were influential for a time in that later collections would draw upon these earliest sources of church law. It was in the East, after Constantine I's Edict of Milan of Toleration, that arose the first systematic collections. We cannot so designate the chronological collections of the canons of the councils of the 4th and 5th centuries. The oldest systematic collection, made by an unknown author in 535, has not come down. The most important collections of this epoch are the Synagogue Canon, or the collection of John the Scholastic, compiled at Antioch about 550, and the Nomocanons, or compilations of civil laws affecting religious matters and ecclesiastical laws. One such mixed collection is dated in the 6th century and has been erroneously attributed to John the Scholastic. Another of the 7th century was rewritten and much enlarged by the schismatical ecumenical patriarch Photius. In the Western Church, one collection of canons, the Collectio Dionysiana, exercised an influence far beyond the limits of the country in which it was composed. This collection was the work of Dionysius Exiguus, who compiled several collections that now go under the name Dionysiana. Dionysius appears to have done most of his work shortly after the year 600. His collections contain his own Latin translation of the canons of the ancient 3rd, 4th and 5th century councils, excerpts from a confected collection of African canons, and a collection of papal letters dating from the reign of Pope Siricius to that of Anastasius II. The influence of this Italian collection grew enormously during the 7th and 8th centuries, especially in England and France. It was continuously enlarged and modified, the most famous modification being a version supposedly sent by Pope Adrian I to Charlemagne in 774 and therefore known today as the Collectio Dionysio Hadriana. Besides the Dionysiana, Italy also produced two 5th-century Latin translations of the Greek synods known as the Corpus Canonim Africano Romanum and Collectio Prisca, both of which are now lost, though large portions of them survive in two very large Italian collections known as the Collectio Canonim Quineliana and Collectio Canonum Sandblasiana respectively. In Italy was also produced a popular 5th-century collection of forgeries known today as the Simokian forgeries. Africa possessed a late 4th-century collection known as the Breviarium Hippense, as well as an early 5th-century collection known as the Codex Apurii Causae, also the Breviatio Canonim, or digest of the canons of the councils by Fulgentius Ferrandus, and the Concordia Canonim of Cresconius Africanus, an adaptation of the Dionysiana. In Gaul many important collections were produced, like the collection known today as the Concilium Irreditens Secundum and At the beginning of the 6th century, the Statuta Ecclesiae Antiqua, erroneously attributed to Africa, also from Gaul, France, of the collections known today as the Collectio Canonum Quadripartita and the Libri Duodecimodalibus Causes, composed by Regino of Prum, Gaul. France also produced two immensely important collections known as the Collectio Canonum Vetus Gallica and the Collectio Canonum Dachriana. The latter is called from the name of its editor, Luke de Cherry. The Collectio Canonum Hiberniensis, or Irish collection of canons, compiled in the 8th century, influenced both England, Gaul and Italy. Unlike almost every other region, England never produced a national collection, though English personnel played an important role in copying and disseminating Irish and Italian collections in Germany and France. Around the year 700 there developed in either England or Germany a collection of penitential canons attributed to Theodore of Tarsus, Archbishop of Canterbury. This collection marked a major advance in the development of penitential canonical collections, which had already been in development for centuries, especially within the Irish Church. Collections like the one attributed to Theodore were known as penitentials, and were often rather short and simple, most likely because they were meant as handbooks for the use of confessors. There were many such books circulating in Europe from the 7th to the 11th century, each penitential containing rules indicating exactly how much penance was required for which sins. In various ways these penitentials, mainly insular in origin, came to affect the larger canon law collections in development on the continent. Iberia possessed the Capitula Martini, compiled about 572 by Martin, Bishop of Braga, and the immense and influential Collectio Hispania dating from about 633, attributed in the 9th century to St. Isidore of Seville. In the 9th century arose several apocryphal collections, viz. those of Benedictus Lavater, of Pseudo-Isidore, and the Capitula Angel Remni. An examination of the controversies which these three collections give rise to will be found elsewhere. The Pseudo-Isidorian collection, the authenticity of which was for a long time admitted, has exercised considerable influence on ecclesiastical discipline, without however modifying it in its essential principles. Among the numerous collections of a later date, we may mention the Collectio Anselmo Dedicata, compiled in Italy at the end of the 9th century. The Libellista Ecclesiasticis Disciplines of Regino of Prum, the Collectarium Canonem of Burchard of Worms, the collection of the Younger Street, Anselm of Lucca, compiled towards the end of the 11th century, the Collectio Trium Partium, the Decretum and Epanormia of Eve of Chartres, the Liber de Misericordiae Justitia of Algerus of Liege, who died in 1132, the collection in 74 titles, all collections which Gratian made use of in the compilation of his Decretum Novum. The period of canonical history known as the Novum, a middle period, covers the time from Gratian to the Council of Trent. The spurious conciliar canons and papal decrees were gathered together into collections, both unofficial and official. In the year 1000, there was no book that had attempted to summarize the whole body of canon law, to systematize it in whole or in part. There were, however, many collections of the decrees of councils and great bishops. These collections usually only had regional force and were usually organized chronologically by type of document, or occasionally by general topic. Before the late 11th century, canon law was highly decentralized, depending on many different codifications and sources, whether of local councils, ecumenical councils, local bishops, or of the bishops of Rome. The first truly systematic collection was assembled by the Camaldolese monk Gratian in the 11th century, commonly known as the Decretum Gratiani, but originally called the Concordance of Discordant Canons. Canon law greatly increased from 1140 to 1234. After that it slowed down, except for the laws of local councils, and secular laws supplemented. In 1234 Pope Gregory IX promulgated the first official collection of canons, called the Decretalia Gregori Noni a Liber Extra. This was followed by the Liber Sextus of Boniface VIII, the Clementines of Clement V, the Extravagants Joannes 22 and the Extravagants Communes, all of which followed the same structure as the Liber Extra. All these collections, with the Decretum Gratiani, are together referred to as the Corpus Juris Canonici. After the completion of the Corpus Juris Canonici, subsequent papal legislation was published in periodic volumes called Bullaria. Johannes Gratian was a monk who taught theology at a monastery in Bologna. He produced a comprehensive and comprehensible collection of canon law. He resolved contradictions and discrepancies in the existing law. In the 1140s his work became the dominant legal text. The papacy appreciated and approved the Decretum of Gratian. The Decretum formed the core of the body of canon law upon which a greater legal structure was built. Before Gratian there was no jurisprudence of canon law. Gratian is the founder of canonical jurisprudence, which merits him the title Father of Canon Law. The combination of logical, moral, and political elements contributed to a systematization that was quite different from a merely doctrinal or dogmatic analysis of legal rules. However complex and however coherent, the canon law as a system was more than rules. It was a process, a dialectical process of adapting rules to new situations. This was inevitable if only because of the limits imposed upon its jurisdiction, and the consequent competition which it faced from the secular legal systems that coexisted with it. Quote, in the 13th century, the Roman Church began to collect and organize its canon law, which after a millennium of development had become a complex and difficult system of interpretation and cross-referencing. The official collections were the Liber Extra of Pope Gregory IX, the Liber Sextus of Boniface VIII, and the Clementines, prepared for Clement V but published by John XXII. These were addressed to the universities by papal letters at the beginning of each collection, and these texts became textbooks for aspiring canon lawyers. In 1582 a compilation was made of the Decretum Extra, the Sext, the Clementines and the Extravagants. Novissimum. After the Council of Trent, an attempt to secure a new official collection of church laws was made about 1580, when Gregory XIII charged 3 cardinals with the task. The work continued during the pontificate of Sixtus V, was accomplished under Clement VIII and was printed as Sanctissimi Domini Nostri Clementis Papi 8 Decretals, sometimes also Septimus Liber Decretalium. This collection, never approved either by Clement VIII or by Paul V, was edited by Sentus. In 1557 the Italian canonist Paul Lancelotus attempted unsuccessfully to secure from Paul IV the 4 books of his Institutions Juris Canonici, an authority equal to that which its model, the Institutions of Emperor Justinian, once enjoyed in the Roman Empire. A private individual, Pierre Mathieu of Lyons, also wrote a Liber Septimus Decretalium, inserted in the appendix to the Frankfurt edition of the Corpus Juris Canonici. This work was put on the Index Jocodecis, Pio Benedictine law. At the First Vatican Council several bishops asked for a new codification of the canon law, and after that several canonists attempted to compile treatises in the form of a full code of canonical legislation, e.g. de Louise Pilet, Pisani, Chaise, Colomiati. Pius X determined to undertake this work by his decree Arguum Sane Munus, and named a commission of cardinals to compile a new Corpus Juris Canonici on the model of the codes of civil law. The 1917 Codex Iuris Canonici was the first instance of a new code completely rewritten in a systematic fashion, reduced to a single book or codex for ease of use. It took effect on the 29th of May 1918. It had 2,414 canons. Johanno-Pauline law in 1959, Pope John XXIII announced, together with his intention to call the Second Vatican Council and a synod of the Diocese of Rome, that the 1917 Code would be completely revised. In 1963, the commission appointed to undertake the task decided to delay the project until the council had been concluded. After Vatican II closed in 1965, it became apparent that the code would need to be revised in light of the documents and theology of Vatican II. After decades of discussion and numerous drafts, the project was nearly complete upon the death of Paul VI in 1978. The work was completed in the pontificate of Pope John Paul II. The revision was promulgated by the Apostolic Constitution Sacrae Disciplinae Leges on the 25th of January 1983, taking effect on the 27th of November 1983. The subjects of the Codex Iuris Canonici are the world's 1.2 billion Catholics of what the Code itself calls the Latin Church. It has 7 books and 1,752 canons. Oriental canon law. Distinct from the canonical tradition of the Latin Church is the tradition of the Eastern Catholic Churches. The earliest Oriental canon law collections were called nomocanons, which were collections of both canon and civil law. In the early 20th century, when Eastern churches began to come back to full communion with the Holy See, Pope Benedict XV created the Sacred Congregation for the Oriental Church in order to preserve the rites and traditions of the Eastern Catholic Churches. Since the early 20th century, Oriental canon law had been in the process of codification. Some of these Oriental canon law reforms were promulgated by Pope Pius XII. The codification effort culminated with the Pope John Paul II's 1990 promulgation of the Codex Canonum Ecclesiarum Orientalium, which incorporates certain differences in the hierarchical, administrative, and judicial fora for the 23 sui juris particular Eastern Catholic Churches, which were each encouraged to issue codes of particular law peculiar to each church, so that all of the Catholic Church's canon law would be codified. Timeline. Antiquum. From the Apostolic period, the Church used different collections of law, but development of a single collection which could be used in all courts did not develop until the Middle Ages. 1059, Nicholas II decrees that cardinals have the right of electing the Pope. Novum. The books of the Corpus Juris Canonici were derived from Gratian's work Decretum Gratiani and were integrated with papal decretals, written from 1200 to 1500. 1210, Innocent III promulgates the Compilatio Tertia. 1225, Honorius III promulgates the Compilatio Quinta, compiled by Tancredus of Bologna. 1234, Gregory IX promulgates the Decretals. 1298, Boniface VIII published a similar code on 3 March 1298, called the Liber Sextus. 1317, John XXII added to it the last official collection of canon law, the Liber Septimus Decretalium, better known under the title of Constitutions Clementis V, or simply Clementini, on 25 October 1317. 1319, John XXII promulgated his extravagance in August of 1319. novissimum 1566, Pius V begins a project to unify the collection of law. He wanted to ensure the use of authentic and reliable versions of the Libri Legalis so that the administration of justice did not depend on the version of Gratian that a particular canonical court used. He assembled a committee of great canon law scholars who became known as the Correctors Romani. The correctors were guided by Antonio Agustin of Spain. Pope Pius V did not live to see this project to completion. 1582, Gregory XIII orders republication of the entire corpus iuris canonici as compiled at the time. Codices 1904, Pius X appoints a commission to compile a code of canon law for the Latin Church. 1917, Benedict XV promulgates a complete code, the 1917 Code of Canon Law. 1918, the 1917 Code comes into legal effect. 1959, the 25th of January, John XXIII announces that the 1917 Code would be completely revised. 1963, March 28, the Pontifical Commission for the Revision of the Code of Canon Law is established. 1963, November 12, it is decided to postpone the work of revising the 1917 Code until the end of Vatican II. 1965, November 20, Paul VI inaugurates the work of the Pontifical Commission for the Revision of the Code of Canon Law. 1983, John Paul II promulgates the 1983 Code of Canon Law, abrogating the Code of 1917. 1990, John Paul II promulgates the Code of Canons of the Eastern Churches. 1998, John Paul II promulgates the motu proprio ad tuendam fide, amending certain canons of the 1983 CIC and the 1990 CCEO. 2009, Benedict XVI promulgates the motu proprio omnium in mentem, amending certain canons of the 1983 CIC and the 1990 CCEO. 2015, Pope Francis reforms the matrimonial processes dealing with declaring the nullity of marriage, promulgating the motu proprio mitis iudex dominus ius amending the 1983 Code of Canon Law, and the motu proprio mitis amisricos ius amending the Code of Canons of the Eastern Churches.